I might get the ball rolling now because I know you all are busy people with a lot on. So thank you very much for joining us today. My name is Kathryn Kearley, and I'd like to warmly welcome you to this webinar on behalf of my firm, Hunt & Hunt, where I am a partner. I'm also an accredited family law specialist, and I've been doing family law for quite some time now. My colleague, Vicky Colmer-Ridge, unfortunately is unable to join us today because an urgent matter has cropped up. So most of you who are dialing in today are people who work in the accounting industry, chartered accountants, CPAs, financial planners, and others of you. Today's seminar is about family law and financial cases, and basically what accountants and family and financial advisors need to know. We're going to go through a few things today. I'm going to tell you a bit about what the law is under the Family Law Act in terms of doing a financial settlement, or also known as a property settlement. We're going to look at the four-step approach, which is the approach that's taken by the court in the event that a matter runs to a final hearing, but it's also the approach taken by lawyers when they are helping clients ascertain what is the range of outcomes and negotiate some sort of agreement between the parties. A common question that crops up is, does a couple have to split their assets 50-50? And I'll address that. I'll also talk about some of the key principles that are applied in family law these days, and particularly focusing on disclosure, because we're in a full disclosure regime under the Family Law Act. That's not new, but it's certainly been heightened as of September last year when the new Federal Circuit and Family Court of Australia was established. I'll take you to some of the relevant family law rules 2015, particularly in relation to the documents that people involved in family law matters are required to disclose to each other. I'll also discuss how property settlement or a financial split can be sorted, what are the ways you can go about it, and how it can be formalised, what sort of documents one can use to actually set out what's been agreed. And particularly of interest, I think, to you people will be how can an accountant or financial advisor assist a client who's going through a family law matter? So that's really the agenda. I will take some questions along the way, but possibly it may be better if we save them to last, if that's okay, because I'm sharing my screen and it's a little bit difficult sometimes to run the chat box at the same time. So what is the law? Well, the Family Law Act has been around for a long time now, since 1975, but these days it applies to all people who are splitting up and sorting out their assets and also making arrangements about their children. So it applies to married couples, de facto couples, same-sex couples. The focus today, though, is really on financial cases. So that includes property division or property settlement and what we call spouse maintenance. When a client comes to see a lawyer about a family law matter, they'll often say they want a divorce. And in fact, the divorce is usually the simple part that happens at the end, because you don't need to get a divorce in Australia in order to sort out arrangements for property settlement and parenting. Also, we will usually advise the client about child support, that is under the child support assessment legislation, about the parenting provisions, which are very detailed in the Act, and parties are encouraged to reach agreement to reflect what's in the best interests of their children. We also discuss family violence and that people should always have an up-to-date will and enduring power of attorney. When we're looking at property settlement under the Family Law Act, it covers all types of property. So real estate, shares in public listed companies, shares in private companies, bank accounts, be they sole or joint, home contents, cars, boats, artworks, jewels, hobbies, all sorts of toys, and superannuation can be adjusted between the parties these days. The Family Law Act also ensures that in doing a property settlement, that the financial resources of the parties are taken into account. And this is very important, particularly where a party may be one of a class of beneficiaries under a discretionary or family trust. So, how does a lawyer advise on family law asset split or property settlement or financial settlement? There's really two sets of provisions. One's for married couples, so that's section 79.4 and section 75.2. For couples who aren't formally married, and that includes couples who are in a same-sex relationship but not married, so de facto couples, it's section 90 SM and 90 S subsection 3. And basically what those sections set out is that, and the case law sets out, is that there's a 4-step approach that's undertaken by the courts, and it's also undertaken in negotiations between lawyers when we're helping clients come to some sort of financial resolution. So the first step is to identify what are the assets and liabilities of the parties. So that's identification of the net asset pool. So that is listing all of the assets. So let's say that the home that they have, less the mortgage that's secured over that home, an investment property, less any borrowings over that property, or bank accounts, all of the other assets, less any liabilities. There might be existing liabilities, for example, to the ATO. So identify what the asset pool is and also identifying the financial resources that either of them might have. That's the first thing. And so that's often recorded in a balance sheet. There's a form that's used by the court, which is a balance sheet, which you'll all be familiar with what a balance sheet is. Secondly, that's when the exercise is historical. And that's when one looks at the contributions that have made in the past by each of the parties to what are set out in the Act as being the acquisition, so that's buying, the conservation, maintaining and improving the assets of the parties or either of them. So if we look at acquisition, that's, for example, buying the home. Who made a contribution to that? Conserving the home. Who was responsible for upkeep, improvement, renovations, those sorts of things. And when we break down the contributions, they're in a number of categories. It's really 4 categories. And those categories are financial contributions, which are direct by one party. So that means one party's actually physically put, let's say, cash towards the deposit of the home. There could be indirect contributions made by a party. That might be a party's family has gifted money towards the deposit for the home or loaned the parties on favourable terms the deposit for the home, for example. So that's direct financial, indirect financial, and then we have non-financial, and that can be direct. And that's that really hard work thing, the sort of thing you see those people doing on the block, ripping up carpets, polishing floorboards, those sorts of things where a person might do it themselves. And we also see a 4th category, which is indirect non-financial contributions. And that might be where a member of one party's family have actually helped by doing things, doing renovation. They might be a tradesperson. They might have, say, they're an electrician and done all the rewiring for free. That's indirect, non-financial. And then there's another contribution which is taken into account, and that's the contribution as homemaker and parent, where the court really is of the view through the decisions that we see that, by one person assuming a major role in being homemaker and parent frees up the other person to go forward into the workforce, and it depends upon the couple, of course, to go and earn an income. So that's the contributions. Then we look at forward-looking. Some people refer to that as really an exercise in crystal ball gazing, but it's not quite so vague. Section 75.2 of the Family Law Act sets out specific factors that the court can have regard to in determining what the future needs are. And so there's things such as the age of the parties, the health of the parties, their capacity for gainful, that is paid employment, differences in earning capacity, which have resulted due to the marriage or the relationship's length, those sorts of things. So while you might see a contribution of a particular percentage, it's at that third step where the court could increase a percentage that one party might get. And finally, what is proposed needs to be just and equitable. I think the best illustration of that is it might be all very well to say that each party takes a piece of real property, but as we know, you can't eat real property. And so sometimes the court will make an order, and quite often, that a property be realised so that there's cash. So that's the four-step approach that's applied in the court and has been for many years now. But before you get to that stage, the first stage that happens, and this is where you might first engage with your clients, they might, just going back a bit, sorry, I'm going to talk about financial disclosure in a moment. I skipped ahead one slide. So I just want to talk about this whole question about 50-50 split. I get lots of questions about this. Lots of people agree to split their pool on a 50-50 basis, but we don't have the full figures as to how many people do that, okay? The law doesn't have any presumption of equal contribution to assets, although there have been some law reform publications that have recommended that, but that is not the law here. There's no presumption of equal contribution as a starting point or end point in Australia. And Mallett's case back in '84 is authority for that. It has to be just and equitable. As I said, some people reach a 50-50 split, and you see that more commonly where the parties are both of a mature age, they've both got limited earning capacity, and you know, they've agreed about it, and they've got a significant pool, but there's no rule about that. One thing that you do need to be aware of, and this is often a moot point in family law matters, is that if somebody comes into the relationship with an initial cash or property contribution, let's say they owned a property unencumbered at the date of the marriage, then you can't quarantine that property off. We don't have laws like they do in some states of America, I understand, where you can quarantine that off. What happens is the court will look at the contributions, but there's often a finding made in some cases, in particular in Williams' case as an example, where the different types of contributions made by the other party will mean that that initial cash contribution or property contribution is subsumed by these various other contributions, such as a homemaker and parent. So there's a lot of discretion there, and we're seeing, I was at the Family Law Conference, the National Family Law Conference in Adelaide recently, and there was a lot of discussion about how the court's discretion seems to be broadening over time. One thing that hasn't changed over time is what's a long relationship. You know, 20 years is certainly a long relationship, 30 years very long, 10 years seems to be long, but short relationships are a few years. And it does make a difference as to the length of the relationship, particularly in the Section 75(2) factors. So that's just some observations about 50-50. No presumption, but people certainly do it. In fact, about 70% of all cases that are lodged with the Federal Circuit and Family Court are cases where people have reached agreement, not necessarily at 50-50, but where they've asked the court to reach agreement. So a lot of people aren't aware of that. So the majority of the cases are cases where agreement's been reached. How do we get the ball rolling in family law? It's really important to understand the key principle of full and frank financial disclosure. A client cannot come to you and say, look, these are the assets my spouse knows about, these are the assets my spouse doesn't know about, and I'm not going to tell them about these ones. If they come to me and tell me that I've got a duty to the court and the administration of justice which overrides my duty to the client, I don't have to tell the court that, but I have to tell the client they have to disclose it, okay? So they must make full and frank financial disclosure. Some people are quite upset by that, because they say, well, I've had this account, it's been mine, I've had it, but nonetheless, that's the law. I can't change the law, I can only advise them about the way it works for them. So they must make full and frank financial disclosure, and that's an ongoing obligation. So if things change, they must also update. And in fact, parties to, if they file proceedings, they have to each file a financial statement, and that's updated over time, not every month, but at various stages in the proceedings to accurately reflect what are their assets, their liabilities, their income, and their expenses. So the duty of disclosure is each party has to fully and frankly disclose all assets, liabilities, income, expenses, and financial resources. So as I said, you can't opt to leave something out, and you can't just shift something over into an account. If you put monies in your lawyer's trust account, you have to disclose that in your financial statement. And there are heavy sanctions imposed by the courts for people who don't fully and frankly disclose their financial position. And again, this is nothing new, and it's the subject of one of my favourite old cases, an oldie but a goodie, which is called Black and Kellner. And Black and Kellner was decided way back in 1992, a long time ago now. And in that case, the husband was a chiropractor, and he in effect was running not just one set of books for his business, he was running a few sets of books. The money that came in through credit card payments and checks, he was using in a receipt book about which he disclosed his income to the ATO, but it transpired in the proceedings that he actually was running another receipt book in relation to cash money he was receiving then. And so the husband had sworn on oath that his income tax returns and books were complete and accurate. But as the trial judge said, it appeared that the husband was caught in what amounted to little more than a blatant lie in this regard. Not often the court uses the word lie. Clearly wasn't impressed, the trial judge. And the court found that the husband's income from his practice was much more substantial than the husband had conceded. And that had a flow-on effect in that the valuation of the husband's business was much lower than it ought to have been, and therefore the valuation was flawed. When the husband appealed to the full court, one of the judges of the full court said something very interesting, and that was, I would have been disposed to find that the husband was entitled to nothing, and certainly would not have interfered with a decision by His Honour dismissing the husband's claim entirely. It may well be that the husband was fortunate to get the award that he did. The husband actually got a bit more than 5% of the asset pool from the trial judge's decision, and that was upheld on appeal. So because he didn't do the right thing, he actually didn't get very much of the asset pool. So that's a very good case in point about why people have to disclose. So what processes are there to ensure disclosure? Well, from the very beginning, the family law rules and the Federal Circuit Court and Family Courts of Australia practice direction set out what has to happen. And so parties have to engage in what we call pre-action procedures, whereby they're obliged to give each other financial documents, and I'll show you in a minute what those financial documents are. And also they're required to engage in some form of dispute resolution if they can. But in summary, the documents are income tax returns, notice of assessment from the ATO, super statements, financial statements from any companies, or trusts in which the parties have an interest. So that's private proprietary companies, family trusts, and so forth. And when that disclosure is taking place, the lawyers will review those documents and sometimes get accountants involved. And it's very common once disclosures take place to engage in dispute resolution, including mediation. And a balance sheet, as I mentioned, there is prepared if there's court action or if mediation or arbitration. I'll talk a bit more about mediation and arbitration shortly. So there's processes in the rules which mean the parties have to disclose documents. And also before you file proceedings in the court, a party has to, if they want financial orders, have made genuine steps in order to try and resolve the matter, which includes disclosing. So there's very detailed rules, Rule 6.06, about what has to be disclosed in terms of financial circumstances, earnings, so that's income, vested or contingent interest in property, income earned by a legal entity where they control it, other financial resources, any trust in which they're the appointer or a trustee, or which the child or spouse is an eligible beneficiary, or the party, corporations, it's listed there. So it's really, really broad as to the disclosure. This is Rule 6.06. And if there's been any disposals immediately before separation, that's a year before separation and after separation, then that needs to be disclosed as well, needs to be accounted for. It's almost as if there's a clawback provision, not that dissimilar, I suppose, as there is in bankruptcy. And they actually must make an undertaking as to disclosure, and there'll be an order to do that if proceedings are filed, and a financial questionnaire is also prepared when proceedings are filed, setting out really contributions and all those things I talked about before. This is important. I've highlighted this particular subsection of Rule 606, and that's subsection or subparagraph 8. So what they have to exchange, and what usually happens before any proceedings are filed and as part of the initial negotiations, is 3 of the most recent ITRs, 3 of the most recent notice of assessment, an up-to-date superannuation statement from any fund in which a party has super. If there's a self-managed fund, the trustee needs to be a trust deed needs to be provided. If they have an ABN, then the last 4 BASs that have been lodged. If there's a partnership, trust or company, but not a public company, 3 most recent financial statements, and last 4 BASs for that partnership, trust or company. So quite a lot of documents are collated. And in Schedule 1, Part 1 of the Family Rules, it sets out further lists of documents and why this takes place. And it's all about early and full disclosure to try to avoid legal action, to try to reach settlement, to try to ensure that the cases are resolved quickly, to limit costs, and really to try and ensure that conciliatory and constructive negotiations take place with a view to settlement. Paragraph 4 of Schedule 1, Part 1 of the Family Law Rules sets out what the parties are required to exchange, and it's quite detailed. So you'll often be involved as an accountant working with a party or a solicitor to try and get all those documents together if you're in possession or control of those documents. So moving on, quarantining off assets. I think I mentioned this. You can't do it. The parties can't do it. All of the assets, whether they're owned solely or jointly with another person or entity, or even if one of the children owns them, have to be disclosed to the other side and to the court, even if that asset was owned before cohabitation or if it was acquired after separation. Now, there are some ways, and the way that you can do it is beyond detailed discussion today as to how to keep the other party's contribution to assets to a minimum. And so we have parties who come to see us, or clients who come to see us, who want to use a financial agreement, which people call BFAs, but they're actually called financial agreements. They're not called binding financial agreements. To become binding, they have to satisfy a whole lot of provisions in the Family Law Act. Some people call them prenups. And what the attempt is in those sorts of agreements is sometimes to limit the contribution of the other party to one party's assets. It can be done, but it's relatively complex as to how it's done, and it's not something that can be done retrospectively. So how is a property settlement sorted? Some people have negotiations between themselves, and in the days of Excel spreadsheet, they will go through and do a spreadsheet, and they might have a different percentage split in different pages of the spreadsheet, for example, and negotiate between them, looking at what they've got now and where they want to be in 5 years. That happens from time to time. Sometimes parties are assisted by other experts, such as accountants. Sometimes parties will sit down with an Excel spreadsheet and with their accountant. They mightn't trust each other anymore, but often they'll still trust their accountant who's known them for an awfully long time, and who can sit down with them and review the items on the spreadsheet and how they might be split, particularly in light of the fact that there are some ramifications that flow from realising assets. There is some CGT relief, which depending where there's transfers between parties and so on. And there's also stamp duty is exempt if you do orders by the court or a binding financial agreement. So there's implications that flow. So that can sometimes work. Or there's negotiations between the parties and through their lawyers. And that is another way to proceed. These are all of the different ways they can be sorted. When a client who has split up from their partner comes to see a lawyer, we'll talk to them about all the different methods. And one of them is mediation, but mediation requires full and frank financial disclosure and preparation of case outline documents and position papers beforehand. So it still costs money, but it's a very suitable process where an independent third party who's a qualified mediator, I'm a qualified mediator, obviously I can't mediate disputes where I act for the client, but the mediator acts as a facilitator to help the parties identify what the issues are, what they seek to achieve, generate options and reality test those options with a view to coming to some sort of settlement. The mediator doesn't impose a settlement, they encourage the parties to reach their own. Arbitration is another way forward. Increasingly, people are availing themselves of the arbitration list within the Federal Circuit and Family Court of Australia, whereby they can agree to appoint an arbitrator. And the arbitrators who are currently appointed are also accredited, and they are really senior family law practitioners. So rather than go to a judge and wait for, perhaps 12 months or so in the system, an arbitration, once you've had full and frank financial disclosure and prepared documents, can take place. Another option is collaborative practice. A number of family lawyers, including myself, are collaborative practitioners, and that's where when a party comes to see you, you sign a contract with them that you will help them reach a collaborative settlement and you will cease acting if it becomes necessary to file proceedings. Again, it's not a cheap process, but it's a very worthwhile process. The parties each have a collaboratively trained lawyer, and there's other people involved as well, and usually a financial person, and if there's parenting issues, a parenting expert, to try to work towards reaching agreement. And you have a series of meetings with agendas for those meetings working towards resolution. Not for everybody, but in growing more common. Conciliation is a mandatory part of the court system. If you file proceedings, there will be a conciliation conference in relation to financial matters. And then litigation is considered to be the last resort. That's because it's expressed to be so by the Federal Circuit and Family Court of Australia, which has a big emphasis these days on dispute resolution. And because best practice in family law is exhibited by conciliatory, constructive way, minimising risk to the parties and trying to resolve matters in a reasonable time period without expending disproportionate amounts of money in terms of the outcome. So they're really the 8 methods as to how to sort property settlement. So how's it sorted within the court? Once parties file proceedings, they're bound by the central practice direction of the Federal Court and Family Court of Australia. And if you want to go and have a look at that court's website, it's a very new website. It was set up in September last year. It's got a nice look and feel to it, very efficient search engine on it. And you can find there the central practice direction. It sets out the core principles in family law proceedings and also case management to reduce unnecessary cost and delay in family litigation, to facilitate proceedings being conducted with the least possible acrimony in order to minimise harm to the families and the kids, to ensure safety and to ensure that justice, facilitate just resolution of disputes according to law and as quickly and as inexpensively and efficiently as possible. I'll admit, that it's hard to avoid acrimony. There are some people who are very distressed, understandably, by a breakdown of a relationship. And so one of the things that I do as a family law professional is I talk to clients and I recommend that they go and seek advice about those areas from another professional. I'm not a qualified psychologist, and that's not what I do in my business, but I recognise how important it is for family lawyers to understand what work's done in other fields. And so I refer people to a GP so that they can go and get some advice from a psychologist or even a psychiatrist if that's appropriate. It's very stressful going through a breakup and trying to sort these things out. So that's important. And that's why sometimes it does take time. This little diagram here is taken from the Federal Circuit and Family Court of Australia's Central Practice Direction, shows the first court event, an interim hearing, dispute resolution, compliance and readiness, trial management, final hearing. That looks really simple. There's actually a number of directions hearings that take place between those so that it can be kept on the rails. Cases are heavily case managed and they're assigned to a particular judicial registrar to manage the cases, and the aim is to try to dispose of, that is, have a final hearing in cases within 12 months of when proceedings are filed. Now, that doesn't always happen. It really depends upon the complexity of the case and also resourcing within the court. And it depends upon whereabouts the parties live. They're more likely to get it disposed of within 12 months if they're in one of the major metropolitan areas because there's more court resources there. I should also say that what they do is they list that the court proceedings these days are run by way of Microsoft Team, and so the court actually uses judicial officers from other states and other registries, so they take this national approach. So if parties are able to reach agreement, that is by way of the negotiation direct or with the help of someone else or with a lawyer or through mediation or arbitration or in the system, then consent orders are required. So if the parties haven't filed proceedings and then they reach agreement, I, as a family lawyer, and most family lawyers would recommend that the parties enter into what is called an application for consent orders and a consent order document. So the consent orders are the orders that are made by the court, and the application is the document that asks the court to make those orders. And the application has set out within it basically a summary of the parties' asset position. So it'll set out all of both parties' assets, liabilities, their financial resources, their income, and so forth. And it will also set out contributions that they say they've made over time during the course of the relationship for each of the parties. And it will set out what the asset split is in terms of percentage. The consent orders will set out what it is the parties have to do. So whether or not one party transfers their interest in a jointly held property to the other, or whether a property is sold and how the proceeds are divided. And so it's the application to consent orders and the consent order documents that are lodged with the court along with a filing fee. And then it comes before a registrar. And the registrar doesn't simply rubber stamp those consent orders. They are required to actually do the figures and decide whether or not the outcome is within the range. And the registrar can actually issue requisitions, that is questions, requiring further information if need be. So the lawyers draft the application for consent orders based on the client's instructions, and you have to have separate lawyers for that, or at least the lawyer for the person who's drafting, who is the applicant for the application for consent orders. You can't have one solicitor drafting an application for consent orders because we can't act for both parties. There's a conflict of duties and interests there. So the consent orders are drafted by the lawyers and they're signed by the parties and their lawyers and then submitted to the court. The other option is a financial agreement which parties can enter into. My advice is always to do an application for consent orders because they are more watertight than any financial agreement. There's very limited ways to set aside consent orders once made by the court. Financial agreements can be done before a relationship, during a relationship, or after a relationship or separation, but there's very strict requirements that have to be satisfied, and a party has to get written advice from their lawyer, and they have to disclose assets in schedules to it. And there's been a number of cases, some of which have gone to the High Court in relation to financial agreements and whether or not they be set aside. So I always say be cautious about financial agreements. Why get proper advice? Now, this is something, there's a lot of information around. If you Google it, there's plenty of stuff out there on the internet, but every case is determined on its own facts. What happened in that particular relationship, and every relationship is different. So a client shouldn't rely upon what happened to their friend, their mate, or colleague, or their relative, and they shouldn't really rely upon what they find out by Googling the law or cases. By all means, they should have a look at what's on the website of the Federal Circuit Court and Family Court of Australia, and there's some useful links there to publications by the Commonwealth Attorney General's Department, as well as court publications. But it's much better to get advice early. We do a lot of pre-separation advice. I have a look, regularly people who come in and they don't know whether they're going to separate or not, and they get some advice about what's entailed. Some people stay together, some people don't. And get proper advice from an accredited specialist in family law. There's a lot of people out there who do family law. Some of them I would classify as people who dabble in family law. I think it's much better if you go to somebody who just does family law most of the time. I guess it's as if people of my age often have knee reconstructions. I wouldn't go to somebody who did a knee reconstruction once every 6 months. I'd rather go to someone to fix my knees who does knees all day, every day. Hence the reason to go to a proper specialist in law. And that lawyer, when they're retained, can work with your client's, the client's accountant, and there may also be evaluation of corporate entities required. Of course, if you act for the client, you won't be able to value it. And there's a number of forensic accountants that do family court. They actually specialise in that. So it's really important to get proper legal advice. I've talked for a while now, and what I'm going to do is just take you to this slide now about how you, as an accountant or financial advisor, can assist a client. And then I'm going to pause to take any questions that you might have. So it's really important that we work as a team. If you're the accountant or financial advisor who's referred a client to us, or working with a client who's going through a family law matter, because it's you who can help the client collate income tax returns, notices of assessment, BASs, company constitutions, company returns, partnership returns, trust deeds, variation of trust deeds, small managed super fund details, and the deed for the super fund and other documents. It's also the accountant who can work with the client to get up to date with their income tax returns. Not everybody's up to date with their income tax return. It's only it's September tomorrow, so a lot of people won't have done their 30 June 2021 income tax return for various reasons, and so it's important that the accountant work with the client to try to get the ITRs up to date, and also to find out if there's any liabilities owing to the ATO, and for those people who are in PAYG arrangements, to find out what their liabilities are, over the next 12 months. An accountant can also help a client prepare some of the forms that are required. For example, a financial statement if proceedings are filed, or a balance sheet if they're going to go to mediation, or if there's a conciliation conference. Very importantly, an accountant can give the client advice about current and future tax liabilities, income tax, CGT, GST, duty, those sorts of things, and where any exemptions might exist. They can also, accountants can give advice about how to structure a settlement. We all know that when you're setting up a business structure, that often tax concerns will dictate the structure that's actually selected by a client. Similarly, in family law, it's sensible to think about what sort of structure might be important going forward. You can give advice about contingent tax liabilities. And one of the things that's really important, and I do a fair bit of work for people who are out in rural areas. I am a member of the Riverina Regional Law Society and the Central West Law Society, and I visit both of those places regularly, is to engage in business succession planning, so that if there is a split happening, then and there's adult children, then what's the role of those children in the business? Quite complex issues arise there. The other thing that accountants can really meaningfully participate in is at roundtable conferences to discuss settlement. So to be available, and I had a mediation last year in a complicated matter with quite a number of different corporate entities, and the accountant was basically on call throughout that day of that mediation, which was resolved on terms which both parties were really pleased with. And that accountant was able to be there and clarify any concerns or give some advice about possible ramifications. So really important, the accountant's role. And of course, too, there are some of you who might come from firms where you actually do forensic accounting work. And I want to explain how that happens under the Family Law Act for those of you who aren't familiar. The regime that exists now is the appointment of the preference of the court is for the appointment of a joint single expert. So if somebody's going to value the corporate entities that the parties have, let's just say there's a number of companies, for example, then it would be for one forensic accountant to value all of those entities, and that valuation is prepared on the basis of joint instructions from, let's say, the husband and from the wife, and the lawyers for both are copied into all communications. In order to depart from that single joint expert, you have to actually get an order of the court and put forward pretty good reasons as to why it's appropriate. So that's the way that works. So some of you might be involved in that sort of work. So I'm going to just pause here, and I'm going to stop sharing my screen so I can see if people have any questions as to what we've been through. So if you've got a question, that's great. I can't see everybody. I'm trying to see everybody. Let me just see if I can get the view on. So I'm just getting the gallery view. Got about 16 or so people. What I might get you to do, I can't see you, but if you just want to say your first name, for example, or if you and just say if you've got a question, then I can respond to that question. I know we've been through quite a lot, so I'll pause for a minute to see if you've got any questions. Anybody got any questions? Or you can pop them into the chat box if you'd like to. Whatever suits you. Okay. Anybody got any questions? Oh, yes, here we are. Someone's put one into Q&A. In relation to private company shares, what if the company acquired an asset after separation and only one director? Thank you for that question, Ashley. With private company shares, yes, they'll still have to be disclosed, and you disclose that it's after separation and only one director. There'll be some value that needs to be attributed to it, and it really depends upon the value. It could be a $1 company, or it could be something that's worth a lot more. But there's no the party just can't just say, look, that's after separation, I choose not to disclose it. If there's proceedings are filed, it will have to be disclosed on the financial statement that's lodged by that party. And if there were negotiations at a mediation, then it would need to be disclosed in the balance sheet that's prepared collaboratively by the parties before that mediation. And that just leads on to a thing, is why it's so important for parties to try to resolve matters in a timely manner, because it's not until they've resolved and actually had the consent orders made that they're free to go on and engage in all sorts of what might be speculative ventures or, you know, business ventures that are going to come to some fruition. Okay, and if one director via a loan agreement with a related party, yeah, you really need to get advice about that as the specific circumstances. Now, Robert's asked a question: are past contributions to day-to-day household expenses relevant to settlements, groceries, purchases for children? That's a good question. So what I talked about before was contribution to the acquisition, conservation, and improvement of property of the parties or either of them, and as well as homemaker parent. When we prepare for a mediation, we will address as to who paid the household expenses, that is groceries and purchases for the children, over the course of the relationship, because that's part of homemaker parent. We all know kids are expensive. Also too, and I haven't really gone into much detail on this, there's separate elements to a family law settlement. One of the elements is a property or financial settlement, but another element is child support. If the parties can agree between themselves and have a consensual arrangement and not record that and one pays the other, and that might work, what other people can do is go to the Child Support Department of Services Australia and submit to an administrative assessment, which is based on a complicated formula, in essence relying upon each party's taxable income for a period, and there's a formula applied, or they can enter into a child support agreement, a binding child support agreement. And most people who are, you know, relatively well off, that is, they've got kids at private schools, they have private health funds, will enter into a binding child support agreement going forward. So in essence, Rob, yes, past contributions are relevant, but not as relevant to the really big picture thing, that is, you know, payment of rates, payment of improvements, payment of mortgage, payment of stamp duty, etc. And then there's another question: net value of new asset is nil. Oh, thank you for clarifying that. Even if it has a nil value, it needs to be disclosed, because the issue is if something is not disclosed and you ended up in consent orders under Section 79A of the Family Law Act, which is the section that sets out when orders can be set aside, where there's been duress or there's been failure to disclose, that's one of the reasons to set aside orders. So all the more reason to disclose, even if it's got a nil value. Now I'm just going to scroll down here. So I'm just trying to scroll down further. I'm just bear with me while I scroll. Okay, now I've got this. Why does the family court not take into account tax considerations in their... Okay, that's a good question, Rod. What the family court does is, and I have this in a case at the moment, we all know that if you've got a property, real property that's an investment property, that if it's disposed, the act of disposal will trigger CGT. However, there is some relief there in that the CGT, if you transfer that investment property, let's say the husband and the wife hold it together and the husband transfers it to the wife, then that is not a disposal and there's not CGT payable on that disposal to the wife. The CGT, under my understanding, becomes payable when the wife finally disposes of that. The court doesn't take into account what happens on CGT. So basically, what they'll say is they'll just say that the parties have to sell the asset and pay out any mortgage and pay the agent's commission and pay the lawyer's fees on sale. and then the parties would be expected to bear that. However, that's one of the reasons why it's really important for parties to think and to try and join those 70% who do go to the court by consent and ask for consent orders, because then they can do the figures on their spreadsheet as to what the CGT is and come up with a net figure. There has been some discussion about whether the court should take these into account. They will. Look, if there is a big issue with respect to tax, then that's something that you could get an expert to put before the court. But, you know, as I've said to a client that I've been talking to recently, it's important that you understand that if you dispose of it, that's a CGT you have to both pay, because, you know, sometimes clients will say, well, why would I have to pay it? Because the reason why we're in this predicament is because the other person left the relationship. But of course, fault doesn't come into it under the Family Law Act. So I'm just going to go further and see if there's anybody else who's got any questions. I'll just see if there's any more questions. I'll try and go down here. I'm just having some problems scrolling at the moment. Oh, okay. Oh, hello, Jacqueline. There may not be any impact on value if the company bought the asset with cash, converts one asset into another, no net effect. Even so, thank you, Jackie. Even so, it's important to disclose it, yeah, because if there's any non-disclosure, it can be work adversely against the client, yeah. And so what you see happen, I mean, I've had, you know, you have situations where somebody has cash and then they don't have cash anymore because they've got their 18-year-old's got their driver's license. So they've been generous and bought that kid a car. So instead of cash being in the bank account, there's now an asset which they own because they usually own the 18-year-old's car. Okay, let me just scroll down and see if there's anything further. Okay, Rob, thank you. Is it compile the details of the past for each individual? How many years? Right back to the very beginning. And so what I give clients to do, there's a financial questionnaire that has to be filed if you start proceedings. I now use that to get instructions from my clients, where I send that to them up front very early on and say, fill this out. We'll need to do this later on. But it gets them to set out all of the details about past financial contributions, right back to when they first started living together or they were married, whichever was earlier. And so you're going back a long, long time, and it takes a lot of time for people to go through those records, and sometimes they might not have the records still. They're relying on their memory. So all the years back to the beginning, because what you do is you're looking at, the court will have regard to the assets at the date of commencement of cohabitation, the assets at the date of separation, and the assets now. And the law is that it's the assets as at now that are taken into account if you run to a hearing today or if you're in negotiations. A lot of parties will want to say it should be frozen at the date of separation for various reasons, but the situation, what the court does is says it's the assets as at now. So that's, any other questions? I think I've got all of them. Pop in any other questions if you have them. I'll just go scrolling down to see. Oh, inheritance. That's a really good question. Look, inheritance is a great question. It's quite complicated. If somebody has inherited money, that is, let's say mum has died and that estate is being administered because letters of probate are about, so probate is being administered at the moment. So they know there's money there, and they know what they're getting under the will, but not exactly. Yes, that can be taken into account. Likewise, if the person dies, let's say mum dies intestate and there's letters of administration. But expected inheritances, well, it really depends, because if mum is really well, she's a sprightly 85-year-old who walks 18 holes of the golf course 3 times a week and doesn't look like shuffling away until she's 100, then really that doesn't have any play on it. So it's often people will talk about, they want to raise, oh, look, they'll be really wealthy. So it really depends on how far off that inheritance is. You know, there's some interesting ways we deal with inheritance. I've had a number of cases of late with people of my age, you know, sort of mid-years, and where they come into some money and the whole thing is, well, that's my inheritance, that's coming from my side. And often we can do some really sensible negotiations where we say, yeah, we get what you're saying about that. You know, you don't want your spouse to have it, but is there a way we might, if you've got it now, divide it between your children? Because then often people will say, well, that's fine. Yeah, we can help our children out, and it gets rid of that issue. So we use these creative ways of dealing with things when you get to that sort of point. But yeah, inheritances can be taken into account. It depends, you know, at the stage of where the inheritance is. Likewise, windfalls, you know, from lottery winnings and those sorts of things are taken into account. And there's quite a few interesting cases on those. Any other questions? What I might do now is just wrap it up shortly. As I said, I'm Kathryn Kearley from Hunt & Hunt. I'm a partner here. I was at Hunt some time ago and came back here a couple of years ago. I'm physically based at their Macquarie Park office, but I'm also do work in the city office and out of our Griffith office. And I service clients right throughout New South Wales and also in southern Queensland. Got a team of lawyers here. My approach is to have a constructive approach to help people move forward and not back. That is not writing letters that just fight and further throw flames into the fire. I try to work with clients to move forward with their lives so that they can come to some sort of resolution on a timely basis. So I'd be really happy to work with any of you. If you have any questions, drop me an email. Or you can give me a ring, and I'd be happy to help you and your clients going forward. Thank you so very much for dialing in today. I hope you now get a chance to have a bite to eat, and we'll keep you on the list for next time we do a family law webinar. Have a really good day. Thank you.